Having heard what makes the business litigator unique amongst his or her peers, now we are going to hear from two of the best business trial lawyers what makes the business trial unique and special amidst the field of other trial work. Please give a hearty round of applause for two dynamos in the world of trial work, Michael Weaver and Patrick Lannen, for a discussion moderated by Linda Oszust.
All right. We're going to talk about the business trial. See if I can adjust this mic here. All right, forget me. Let's move on. All right. So our speakers are Michael Weaver, who recently made a move to flood law. Michael Weaver is probably one of the most ubiquitous trial attorneys in our area of law. He's tried over 90 cases, is that right? Yeah, and he just crushes. If you haven't heard of him, check him out. So he's one of our speakers, and we've got Pat Lannen. So Pat is a founding partner of Stitnar Lannen, am I saying it right? Steiner Lannen. If you haven't heard of him, you should have. He's done some incredible things, some incredible trials. We've just got two incredible trial lawyers on the stage right now, and so that is the subject of this segment. We are going to ask them some hot topics and hear what they have to say about the practice of the business law trial. So we're going to start with career moves, and we're going to start with Mike here, I believe. You've both made some major career moves this year. Mike, can you tell me about that and what factored into your decision to make a move?
Every 36 years, I try to change jobs. That's what I do. No, I had just started looking for something different to do. There's a lot of conflicts on cases I wanted to bring in at Plunkett, and it's still a great firm. But at Todd Flood's office, I have way less conflicts. It's much smaller. It's easier to manage. It's easier to be around the young people. And they've really, I'll steal a line someone else said, it's been like Viagra for the career. It's really been so rejuvenating, and I'm excited to come into work again, and it's just been a lot of fun. So it was just time to move.
All right, and Pat, tell me about founding your firm.
Well, without Mike, I couldn't get to go to work every day anymore. So I had the opportunity to know, truly, the reason is because my good friend and business partner, Parker Steiner, who has done some really impressive things inside and outside of Michigan in some very large mass tort and other data privacy class actions, offered me an opportunity to start a firm with him. And we just had a view that maybe Michigan could use a new way of thinking in terms of that line of business. So the plan was to contribute to the community, look into the data privacy and class action business, and here we are.
Okay, so our next topic is the business trial. You guys are unique amongst your peers. Amongst business lawyers, you two might have some of the most trial experience around, both in and out of the business arena, which makes you special. Pat, let's start with you this time. Tell us about what you think is and is not consistent between the trial of the business case and another type of matter.
I think what Bill Winsten said earlier is probably the most unique thing. The record is perhaps a little longer, a little more convoluted. The emails go both directions in a business trial. And so the most unique thing amongst its peers would have to be a desire to watch to conclusion a cohesive theme that you can deliver all the way through and do so very simply.
Mike, same question.
Yeah, I have found that the business lawyers have a much better command of the rules of evidence and the rules of civil procedure, more so than any of the other areas where I've tried cases. So that makes it different. It keeps you on your toes a little bit more. I've figured out that business lawyers are really smart. Now, a lot of them don't like jury trials. I happen to love jury trials. I think, and I'll be respectful to the judges here, I'd rather take my chances with 8 strangers than a judge who's already seen it all. And they've heard us argue discovery motions, and they've heard us argue dispositive motions, and they are tired of the case, as they probably should be. And so I've found that jury trials in the business court are fantastic. I've learned to narrow it down. You might have 3,000 documents. You don't really need all 3,000. You probably need about 10. Otherwise, you'll just overwhelm the jury. And again, I've found the business lawyers to be so skilled at getting to the point and making a point to a jury.
Okay, so that is a great segue into our next topic, which is picking a jury. Pat, how do you do it? Do you use jury consultants, questionnaires, voir dire? How do you go about picking your jury in a business trial?
Good question. Picking a jury. I do use jury consultants. I do think trying to understand what a consultant might think about certain visions of a case, certain things that are important about a case. I was preparing to try a case in Wayne County a couple years ago, big case. And unfortunately, the Court of Appeals took it away at the last second, or favorably, I should say. But I spent a lot of money on a jury consultant in that case, and she brought a jury consultant from out of state, and she brought a perspective of here's what someone in the cross-section of the community might find important about this particular asset, this particular building, this particular deal, things that we just weren't seeing because we're so into the documents, so into the law. So I do use a consultant. The other thing I do is just talk to them. In my experience, just hopefully if the judge lets you conduct voir dire, I like to talk to a juror, ask them what he or she thinks about any given topic under the sun. If she knows the lawyers, make connections that way. I think just any regular human conversation will give you more data than you'll ever need to figure out if the juror is a match or not.
Mike, same question, but also, do you use voir dire to prejudice the jury in any way?
Well, you push as far as you can within the boundaries the judge will give you is to try your case during your voir dire. And, every good lawyer does that. I want every advantage I can get. We all want every advantage I can get. And if I can stack the jury with like-minded people who believe in my client, that's what I'm going to do. Now, some judges are very, very tight, and they ask most of the questions, and you can ask some follow-ups. But really, the underlying theme on voir dire for me is you got to make a connection with those jurors. Most judges won't let you call them by name, but if you can, call them by name, memorize their name. You got to know who you're talking to. They want to know that you care about them, because then when you roll into opening argument, you feel like you already have a friend. And I think that that's a way to start the trial going in the right direction.
All right, so we're a team here on stage tonight. Do you all like to work as a team or try a case solo? Pat?
I try cases as a team. Everything I do is a team. I'm not smart enough to do it solo like Mike does. I think the team effort gives you just a diversity of perspectives, and you can share certain witnesses, you can figure out certain ideas, someone else can handle jury instructions. I think trying a business case itself particularly lends itself to a team experience.
Mike, how do you delegate to your team? How do you handle it?
I'm a terrible delegator. I've tried most of my cases all by myself. I am convinced the client gets a much better service with a team. I also am mindful of having too many people on your team, so the jury thinks that you're this big money, especially as a defendant, you don't want to have 9 people and the plaintiff says, look at them. They got 9 people here. That's more employees than we have in our whole company. Right, and I've seen that happen. So I've tried cases when I was a young lawyer for a large national company. They didn't even send a rep. So I'm used to trying cases alone. I do think trying as a team is better. You have to make sure that the person that's on your team participates, because I think it makes it look bad if they don't. I try to bring a younger lawyer with me, and I don't want them sitting there just taking notes and handing me notes. They got to take witnesses. So they have to be really invested in the case so that they can be impactful at the time of trial.
Okay, moving on to technology. I'm going to flip-flop it and start with Mike this time. On technology, do you bring tech support for your trial, like Fort's Legal, who's helping us out tonight? And can it be too much? Can technology be too much?
I think we're in a show-me world. I think juries want the technology. For many, many years, all I used was an Elmo. It made everything a blow-up. It made everything easy. I'd just pop it on the screen no matter what it was, whether it was a transcript or a record or whatever it might be. But now there are so many, that trial pad for your iPad is so slick, and it's almost foolproof. I had a trial in federal court about a year ago where the judge told me he didn't want me to use an Elmo. And I said, okay. And the judge's technology went down on day one. And I said, I'd kill for an Elmo right now. And the judge said, I don't want to hear about your Elmo. So I think technology is here, it's a cliche, it's here to stay. It is vital now, but you better make sure it's dialed in and you better make sure it works.
Pat, what's your take?
Yes, I don't try a case without my favored trial tech. I think he does an excellent job. The trial director's cued front to back. I've gone over the PowerPoint. I probably spend 90% of my time in trial prep on the opening itself, where I think you really learn the case itself anyhow. And I think that today, to try a jury trial on a business case for a business owner who isn't in control of his own destiny without legal is just asking to lose.
Okay, our next topic is changes. Let's start with Pat on this one. How has the conduct of the business trial changed since you were a young lawyer trying your first case till today?
Still a young lawyer.
Take great
I knew you
umbrage
were
with
gonna
the suggestion that I'm an old lawyer, but I think that there's been some turnover in the bench. When I first started practicing, the 2008, right out of the recession era, there were some long-standing judges in all the Tri-County area, but on the federal bench too. And so I think as some time has passed, we see different judicial skill, you see a different judicial experience, and I think you have to accommodate that and build that into your prep as you go. One of the few things I've learned in trial prep, and some of the experts that we've hired, retained, and have consulted with, and I've tried to implement their steps, for better or worse, is the theory of like, trust, believe. Very human, very basic theory. And just because I do that with the jury, and that's what every question we think about that. Every piece of evidence, we think about that. But I think that it happens with the judge too. And so I think implementing changes to your strategy, depending on who the judge is, can be incredibly important.
All right, to the senior gentleman on the panel.
The old guy. Listen, technology is a huge change. I mean, in the old days, we'd show up for trial with 15 big blow-up boards, with photographs of this or big copy of the contract or whatever it might be. Those days are gone. There's no question about that. I think Patrick's right. The bench has changed. Not always for the worse, but it's definitely different. There's some younger judges who probably didn't try as many cases, so they're kind of learning with us, and that's fine. I think Nina's here, and she'll back me on this. We're a more antagonistic bunch than we used to be. I'm trying to get better, but we're in the litigation business, and it's adversarial, and it's rough and tumble, and in many ways, especially in the business world, we want to show our clients, and I'm fighting for you. This is your life on the line. I'm fighting for you, and I got to get better at not going beyond the what's really professional, and still fight for your client.
Okay, next topic is opening statements. I want to start with Mike on this one. Tell me how you prepare for your opening statement. Is everything scripted? Do you go freestyle? Do you use a PowerPoint? How do you do it?
I likely over-prepare because I've read every transcript, every document, every possible piece of evidence. And then I select maybe 4 or 5 documents to put into my PowerPoint. But it's relatively scripted. But when you're doing a PowerPoint, you put it up and you remember 10 things you want to say about that document. And it really makes it go pretty easily. You have to make sure that you're in tune with your tech support so that you're not getting ahead of the game. And that's why the scripted is important for me, because I'll say, Exhibit 6, and I know I got to hit these items before I get to Exhibit 6. And then Exhibit 6 pops up, and you know there's 4, 5, 6, 7, 10 things you want to say. So it's relatively scripted, but you know, after trying a lot of cases, some of it is stuff I've used a lot. So that stuff's really easy. But when you get into the details of the case, the facts and the law, it's obviously unique to every single case.
Pat, do you ever object to opposing counsel's opening statement?
No, I never have.
All right, well, how do you prepare? What do you do?
I spend most of my time in the opening. In my personal experience, I think the case can be won and lost by the end of the opening statement. It's not universally the case, but in my opening statement, I don't script any of it. I do make a PowerPoint. I make a very careful PowerPoint. We put only the best things in the PowerPoint, and we tell the whole story, soup to nuts, and hopefully 20, 30 minutes or less in the opening statement. And I've found that to be incredibly successful. I don't think you need to script it. I think coming off naturally can be very convincing. I think that if you can't do it that quickly, then you haven't spent enough time pounding your slides over and over again. I don't think you need 50 slides in the opening. I think that you can tell the story in 5 minutes or less. And when you illustrate it with the slides themselves, no different than how a producer previews a movie before it goes to the theater, you're doing the same thing in your opening statement.
We're skipping some topics here because they're not as interesting. All right, trial drama. Pat, what's the most dramatic testimony you've ever seen at trial?
The most dramatic testimony I've ever seen at trial. I would have to say the most dramatic testimony that I've personally been involved in at trial would have been arguing this case, I really wanted this video to come in. I wanted a video to come in of a recording that we thought spilled it. The judge wouldn't let me play the video. And so, big witness from California who I had been trying to subpoena, couldn't get her. The defendant decides to bring in one of their key witnesses, this M&A consultant from California. She flies in the cover of darkness. They surprise us, and they're going to call her first. I don't know anything what she's going to say. First question I ask her, whatever the question was about the contract and who said what and what the terms were, she's first answer. Well, there's a video recording that answers that question for you. So she opened the door, the judge played the video, and the rest is history.
Mike, same question.
Okay, this one didn't really impact the outcome of the case, but it is burned into my memory. As I've tried some cases, a lot of times I get called late and come in to just try the case. This case involved a crane incident at U.S. Steel, and a guy named Dan was the crane operator, and the plaintiffs had never deposed Dan. And so Dan gets on the stand. And I said, you know, he's kind of a rough and tumble guy wearing flannels. And I said, I want the jury to know Dan. And I said, Dan, got any kids? Yeah. How many you got? 18. 18. Well, Dan, I'll bite. What's the age range? Roughly 19 to 27. The whole jury, the whole courtroom stops. I said, you got to be kidding. He goes, yeah, you know that week in November when you guys all go up north hunting? Yeah, that's my favorite week. We had to take a break, and it didn't really impact the outcome of the trial, but it was pretty impactful for me. Like, I remember Dan. I think he's on my Christmas card list.
So, with that in mind, preparation is key, Mike.
Yeah.
What do you do early in the case to make sure you're ultimately prepared to go to trial?
Early on, you've got to meet with your client and anyone who could be remotely related to the case. For example, you've got a breach of a non-disclosure, non-solicitation. You got to get out and find out who all the clients are. How do we know this former employee has met with people? What records do we have to say he's soliciting our clients? Tell me everybody who's going to know everything about this client, about this person, about that. Who's the contact person there? Do they have sign-in sheets at that plant where this former employee was going in? You got to get all that down so that there's no surprise when you get into a deposition. And then prepping your client for the dep is so important because I've seen it happen where I'm in a deposition, I'm like, no one prepped this witness, and you just killed them. You just killed them. And so I think the more you can do, I think Bill Winsten said this, the more you can do up front, the better, and the less likely you are to be surprised.
Pat, same question. What do you do to get ahead of the game?
Of course, I'll echo that. I don't think people spend enough time, in my experience, and we're all guilty of it to some degree, prepping your own witnesses. I think that, like anyone else, we sit and we have coffee, and I say, okay, I'm the opposing counsel. Here's the question. What's your answer? And you got to hear them out and see what the follow-ups are. And you say to them, you might consider answering it this way if that's still consistent with the truth of what your answer is. And I think that developing that rehearsal is really key. And of course, the other thing, in a business case, for example, the one thing that I find, we take 20 deps all over the country and we'll look at 3,000 emails and we think all this math is important. And of course it is, in case you missed something, but I also find we come back to very simple things in the 2 to 3 weeks before trial, such as in a business case, itemize your damages. Did we send an interrogatory that says itemize your damages and all the documents that support it and the witnesses that support it? And I think getting those things, annoying as they are, out the door early in the case is really helpful.
Okay, next topic, the ever important closing argument. Pat, let's start with you. What's your technique for being prepared to give your closing? How do you keep track of the case as it's happening and then synthesize it into your closing argument?
Again, PowerPoint, same thing. We try and take a record of what was the most significant thing, get a juror reaction. We're going to make sure we write that down. We're going to incorporate that into the closing PowerPoint. I don't at all script the PowerPoint. I don't script the closing. I prepare the PowerPoint. I just let it come out. However it comes out, I think the jury can feel it when it's real. They can feel it when it's genuine. They know, at the end of the day, trial, as I've read about or learned, it's a truth-seeking function. The point of all this is to decide who's telling the truth. And so at the closing, I think you just tell them, here's the things that actually tell you the truth. Here are the things that tell you falsehoods. And I use terms just that simple. And I use my everyday human experience to find what I think those things are, and we just put them in a closing statement. I think that's just the most real, raw, convincing thing that you can do to close a case.
Mike, do you agree the closing argument is about the truth?
Well, I think that juries generally are for common sense, and they generally know right from wrong. And I try to focus on what is right and what is wrong. I'll use a PowerPoint. I make sure it's not exactly the PowerPoint that I used in my opening. I'll also, if a witness really gave some incredibly compelling testimony, I make sure we order that transcript on an overnight, highlight it. This is what he said. This is what he said. This is what she said. Or I also, if I think opposing counsel has gone way off the reservation on opening, I'll order that transcript as well and say, this is what opposing counsel promised you. That was his promise. That's what he promised to show you, and it didn't show you. Let me tell you why. Here's promise number one. Here's how you know it's not true. And I like Patrick, that's not true, that's false, that's not true, that's false, this is what's right, and this is what's wrong. And so I think when it's not the reptile theory that a lot of the PIs use, but I think at our core, all of our jurors want to do what's right. And you have to convince them that your side is what's right.
All right, I'm going to skip to the last topic because it's the most fun, and we're almost out of time. I'm going to start with you, Mike. What was your most memorable moment at trial?
Well, we had Dangerous Dan. His nickname was Dangerous Dan. I had another one where I was called in late, and I got all the records. This was a PI case. I got all the records from prior counsel, and I had a paralegal kind of organize the records, and I was cross-examining the plaintiff, and I got the records in my hand. You had a surgery 2 years ago on your shoulder, didn't you? No. Well, you had a car accident 3 years ago, right? No. Well, you had back surgery 4 years ago, didn't you? No. And I'm looking at the jury like I got the records. My paralegal had the records from another case. So it was a little troubling. I didn't realize it until after the trial. So that was a never forget moment. I mean, I was looking at the records, at the details, not the name. The trial went well, though.
Pat, same question.
I tried a case in 22 Oakland County. It was a couple week-long jury trial in a shareholder case. And the key witness, one of the key witnesses on my side, I was going to produce him last because he's an idiot. And so I did, but he flew in from Toronto. He's staying at a hotel. He told me to pick him up on the way to the courthouse, which I promised to do. But I was so focused on closing the argument that I forgot to get him. I just drove right to the courthouse. So he had to unsuccessfully Uber to the courthouse from Pontiac. It wasn't a pleasant experience. So my advice is don't forget your witness on the way to court.
Well, thank you guys. This has been an amazing chat. Thank you, Mike. Thank you, Pat. We're going to take a quick break. Feel free to refill your drinks and get a snack, and we'll be back for the next segment.
Thank you to our presenters. Our next scene begins shortly.